If I want to back this up. Hello, Mr. Man.
This our quartet, this thing need a projector. Use this kind of small phone, no go dey interesting. Project everybody dey fear. Or even laptops. If laptop go dey there. Oh. Okay, na the Zoom.
Okay, I'll see the password. You know, huh? Okay, since that you got to hear them here, but join so that in case if the other lawyer wants to talk, you can hear them. But if they are talking now, even if you're a lawyer, you only be hearing my law. Unless you be hearing the noise now from my law. So, man, I'm just there like this is okay. I sit there like this now. I mean, here, man. Mr. Mike. سماك. Proszę, just touch it after. Cut. Identical. Resumed today, Wednesday, 28 July 2021. Before His Lordship, Honorable Justice NCS Ogba. Suit number NICN/LUA/575/2017 between Mrs. Olabisi Taiwo and the Governing Council, Estate Surveyor and Values Registration Board of Nigeria. My Lord. I'm not hearing. Hello.
Hello.
What is he present?
Yes, she's the Olabisi Taiwo. She's the
Present, sir. My Lord, I'm present.
Olabisi.
I will
What are the
present.
defendants?
Olabisi Taiwo is present.
most respectfully, my Lord. FM Jatu appearing for the claimant. The voice, it's not audible.
Zion. Hello, don't be fast.
Is defendant not represented?
Hello. Defendant.
Hello, sir.
Is hello.
Hello.
Yes,
Hello.
announce the appearance, cancel.
Good morning, my lord.
I am.
Good morning, sir.
Can we announce the appearance?
Sir. I can't hear you, sir.
Where is the lawyer?
They are there with us, sir. They are in the meeting with.
Let them announce the appearance. Where about that this morning here? Let them announce the appearance.
Council, please announce your appearance.
Come.
Hello.
I'll announce appearance now. I'm the defendant's counsel, so it's the claimant counsel that should announce appearance first.
Is he not also can say no appearance for claimant?
I appear for the defendant.
So no appearance for the claimant. No appearance for the claimant. Defendant.
Yes, sir. E. Akpofure. I announce appearance for the defendant, the Council of National Estate Surveyors and Valuers.
Okay, good. So no appearance for the claimant. Or is not able to understand the technology we are using. Yeah?
The claimant is with us.
The claimant is not in court, or you can't use his system.
He's in court. I told him, he said he has announced his appearance.
Let him announce the appearance now. We're keeping the record. What is his name? It's surprising that this is coming from Lagos. Lagos lawyers are embarrassing everybody here. Council announce the appearance.
Claimant counsel. Claimant counsel, are you there?
Okay. How long can we wait for him to announce? I will just move on. But I will put my record straight because I didn't hear from him. I don't know who is announcing appearance for him.
Say you, that's the judge.
Has he not joined? I can see somebody is sitting from there, but what is his? Can he announce his appearance now? So I still put my record claimant, no appearance for the claimant, E. Akpofure Esquire for the defendant. So I can proceed with my judgment. This is a judgment emanating from Lagos Division of the National Industrial Court, now being read from Port Harcourt Division, where our live proceedings. The claimant, a chartered accountant who served as chief administrative secretary accounts with the defendant, the regulatory body of estate surveyors and valuers in Nigeria, commenced this suit within a general form of complaint, a complaint with front-loaded originating processes dated and issued on 23rd November 2017, wherein she challenged the termination of employment with the board and prayed for the following reliefs. A a declaration that the purported termination of employment by the defendant is a violation of Section 36 of the Constitution of the Federal Republic of Nigeria and public service rules of the Federation. B, an order for immediate reinstatement of the claimant by the defendant without any loss in rank and seniority, as well as increment and promotion with effect from 27 July 2016. C, an order of mandamus compelling the defendant to pay all claimants' arrears of salaries and allowances from 27 July 2016 up to date of reinstatement to employment with the defendant. Alternatively, the sum of 15 million naira only for unlawful termination of employment. 2, the sum of 2 million naira only being solicitor fees. And 3, the cost of this action as assessed by this honorable court. Defendant reacted with his statement of defense and accompanying defense front-loaded processes and his counsel's memorandum of appearance, all dated and filed on 5th February 2018, and regularized by the court order of 6th February 2018, having been filed and served out of prescribed time without leave of court. As the defendant vehemently denied any wrongdoing in the termination of the claimant's employment and joined issues with the claimant, the matter was set down for trial at the proceedings of 21st March 2018, 23rd May 2018, and 18th July 2018. At the trial proceedings, the claimant opened her case and testified for herself as sole claimant's witness, CW, adopted her witness statement on oath, deposed on 23rd November 2017, and tendered 20 sets of exhibits, admitted in evidence amounted as CT1 to CT20, as described in the claimant's list of documents dated 23rd November 2017. CW was cross-examined, and there being no re-examination by her counsel, her case was closed. On the part of the defendant, 2 witnesses were called and testified as defendant witness 1 and 2, DW1 and DW2. One Ifeanyi Fidelis, who's the registrar of the defendant board, testified as DW1. He adopted his witness statement on oath deposed on 5th February 2018 and tendered 1 exhibit, admitted in evidence and marked as a DT1, described in the defendant's list of documents dated 5th February 2018. One Andrew Irigi, an auditor staff with audit firm of Zoe Burukwe and Co., the defendant's external auditor, testified as DW2. He tendered 4 exhibits, admitted in evidence and marked as DT2 to DT5, as described in the defendant's list of documents dated 5th February 2018. DW1 and DW2 were cross-examined, and there being no re-examination by defendant counsel, the defendant's case was closed. Case of the parties. Going by the pleadings and testimonies of the parties, the case of the claimant is that, being a chartered accountant, she was appointed by the defendant board with a letter of appointment dated 29th October 2020 as administrative secretary accounts, that's the CT1. And after a successful probation period of 6 months, her said appointment was confirmed by a letter dated 8 July 2004, wherein she was moved from grade level 10 step 4 to grade level 10 step 6 as the CT2. And she was later designated as Chief Administrative Secretary CAS accounts with specified duty schedule, which basically made her to be in charge of the account department of the defendant board. That sometime in January 2015, she was issued with a query dated 26 January 2016 by the registrar of the defendant board, SBCT3, of which she replied promptly in her response, query dated 27 January 2016, SBCT4, and explained how the complaints raised in the said query, particularly as it concerns her alleged failure and refusal to carry out the decision of the board on increase of staff salaries, that yet by an internal memo dated 11/02/2016, titled, "Oh, what God has done," XBCT5, which the registrar sent to her, the registrar raised a number of official issues in a petty manner. And a few days later, the registrar issued her with another query dated 15 February 2016, bordering on alleged comments and consistent poor performance rating made by the external auditor, that's the CT6, of which she responded to in an undated response, that the query, that's CT7. That the registrar, the countenance, has said response and issued yet another query repeat query dated 20th June 2016, XBCT 9, of which she again responded to by her response memo dated 21st June 2016, XBCT 10, and explained out the issue of unaccounted cash receipts, and that this response was followed by another query dated 26th June 2016, XBCT 11, which she also responded to by her response memo dated 27 June 2016, XBCT 12, and explained again how the cash shortfall could have arisen due to pressure of work and not deliberate efforts to steal. CW further narrated that by a letter dated 27th July 2016, XBCT 13, has said employment was terminated. That as requested in the said termination letter, she sent in her handover note with all official items in her possession, which were received and acknowledged in the XBCT 14. And that by a personal letter dated 10th August 2016, XBCT 15, she wrote to the claimant, to the chairman of the board, that's the essence of your elder William Odudu, requesting that the letter of termination should be replaced with a letter of restatement, contending that employment with S-Varo, that's the defendant, is employment with federal government of Nigeria and governed by civil service rule. That has said letter of 10th August 2016 was responded to by the registrar, who by a letter dated August 11, 2016, XBCT 16, confirmed that the termination was based on the decision of the board taken at the meeting, that's board meeting, held on 27 July 2016. That she wrote another letter directly to the defendant board, XBCT 17. And the solicitor also wrote a petition dated 14th February 2017 to the Federal Civil Service Commission, Abuja, XBCT 19, regarding the manner of the unlawful termination of the employment without due regard to the procedure set out by the Public Service Rules, of which the Commission responded to by a letter dated 1st August 2017, XBCT 20, wherein it advised that the matter is to be directed to the defendant governing board, being the appropriate authority to deal with the matter. It is also the claimant's case that has said termination was done without due process and in violation of civil service rules, which guides her employment with the defendant, and also without being heard contrary to Section 36 of the Constitution of the Federal Republic of Nigeria and the civil service rules, and in gross violation and disregard to the principles of natural justice. Claimant also contended that her termination of employment was a product of serious victimization against her by the registrar and the chairman of the board for performing her duty proficiently and with integrity, in line with her professional calling as a chartered accountant. And that the committee that heard her case comprised of the board chairman of the registrar and who had grievance issues with her, thereby breaching rule of natural justice that one should not be a judge in his own case. CW concluded and urged the court to grant the claimant's claims and order her restatement. On the other hand, the defendant case tallies with that of the claimant on the employment history and incidents of the queries issued to the claimant and its culmination in the termination of employment, but differed markedly on the status of employment and the alleged breach of rules of fair hearing. The defendant contended that it did not set up, that it did set up a committee to investigate the breaches and lapses as highlighted in the management report of the external auditor, Joe Ibuku and Co., Chartered Accountants, dated 28 January 2016. That is the DT1, also tendered as CT18, in performance of the duties of the claimant as the defendant's accountant. That is said external auditors, upon auditing the financial affairs of the defendant for the year ended December 2013 and 31st December 2014, found that among other issues that there were differences in cash balances emanating from cash received by the claimant but not lodged into the dependent bank accounts with its bankers, Zenith Bank and First Bank, and such sums were not accounted for. That the external auditor in their audit report dated 24 June 2016 and management report of 26 January 2016, the DT1, put the difference in the cash balance as at 1st December 2013 to 645,000 naira and 28,000 naira for the other period of 31st December 2014. It is also the case of the defendant that the claimant in her response dated 21st June 2016, XBCT 10, to the query of 20th June 2016, XBCT 9, issued to her, admitted the differential cash shortfall in the sum of 645,000 naira and as indicated in the said external auditor's management report to the defendant, DT1, of which 4 staff, including the claimant, was involved, that the claimant issued a debit note to herself and other affected staff for recovery of the said loss sum of the DT2 to DT5. DT1 went on that following the claimant response to the said query of 20th June 2016, wherein the claimant confirmed the said shortfall in cash remittance in the defendant's account as revealed by the audit amounts to admission, which prompted the defendant to issue to the claimant another query dated 24th June 2016 as CT11 to explain why she should not be punished for stealing and breach of the board's financial propriety. It was further contended for the defendant that following the claimant's response to the said query, the defendant proceeded to set up the Executive Finance and General Purpose Committee, who investigated the dereliction of duty by the claimant, by the management, and found her culpable and recommended to the claimant and three other staff who took money of the defendant should be that 3 of them, including the claimant, should be disciplined. That the defendant, acting on the recommendation of the said committee at its board meeting of 27/7/2016, approved that the appointment of the claimant and the other 3 hearing staff be terminated and made to refund the sums that were collected by them. It is also the case of the defendant that the claimant was given opportunity to defend her actions or allegations as pointed out by the external auditor in their said management report, of which the claimant confirmed in her response of 21st June 2016 with CT10. And that the defendant in terminating her employment also considered the claimant's criminal act of taking his money without due permission and approval and possible report of the action to the professional body which the claimant belongs to. The DW concluded contending that the suit is vexatious, frivolous, and lacks merit, and urged the court to dismiss it with substantial costs. Counsel submission. Upon conclusion of trial, filing and exchange of final written addresses was ordered, all which both counsel complied with. Learned defendant's lead counsel, Emena Apofue, in his unnumbered 10-page mini final written address dated and filed on 10th August 2018, raised the sole issue for determination. That's whether the determination of the appointment of the claimant were wrongful. Counsel canvassed associate arguments, legal authority in support of the defendant's case. On the side of the claimant, learned lead counsel, claimant E.A. additional JPS, 9-page final written address settled with B.A. Adua and A. additional, raised 3 legal issues for determination. That is one, whether the employment of the claimant was determined in accordance with her letter of employment, which forms the basis of the contract between the parties. 2, whether there is a breach of the principle of natural justice in the way and manner the contract of employment of the claimant was terminated. And 3, whether the allegation of crime, that's do with stealing of 23,000 naira only, has met the standard of proof required. Counsel also canvassed sources, arguments, and legal authorities in support of the claimant's side of the case. At the adoption proceedings of 18 June 2021, the defendant's counsel was absent without providing any excuse. Nevertheless, as he already filed and served his final written address, I invoked under 45(7) of the rules of this court to deem his final written address as adopted. Claimant's counsel, who was present, formally adopted his own. The matter was thereafter reserved for judgment, and that's why we're here now. Court's decision. I participated actively in the proceedings, read the processes, as well as intensively reviewed the submissions canvassed in the final written addresses filed and exchanged between both counsels in advancing the case of the respective parties to represent. Also keenly watched the witnesses testify and noted their demeanors and carefully evaluated the evidence tendered and expressed in the proceedings. I've also reviewed the issues raised and canvassed by both counsel along the line of the material dispute between the parties. I find them comprehensive. The modifications will clearly bring to the core contention underpinning the dispute. I have therefore harmonized the issues to a sole legal issue to read thus. That is, given the facts and evidence led, is the claimant entitled to the relief sought. The claimant has set up 3 reliefs, numbered A to C, with 3 other reliefs in alternative, numbered 1 to 3. The main reliefs are made up of 1 declaratory relief and 2 substantive reliefs. As best adjudicative practice, the alternative reliefs are considered only after the main reliefs and only after the main relief and awardable only as the circumstance of the case would warrant. I will proceed along that established path. Relief A seeks for a declaration that the purported termination of employment by the defendant is a violation of Section 36 of the Constitution of the Federal Republic of Nigeria and Public Service Rules of the Federation. The extent of discharge of burden of proof on claimants seeking declaratory relief has been guided in Dean against NMO 2009 10 NWLR part 1149, Supreme Court, page 353 at pages 380 to 381, paragraph F to D, to the fact that even admission of claimants' pleadings by the defendant is not enough to anchor and sustain relief bordering on declaration of rights. To ascertain if the claimant satisfy this requirement, the pertinent question remains: did the claimant lay sufficient and cogent evidence to support her declaratory reliefs? The cause of action occurring in the reliefs sought is the alleged wrongful termination of the claimant's employment by the defendant. In determining wrongfulness or otherwise of termination or dismissal of an employee, the law is that onus of proof is on the claimant's employee who alleges that his or her termination or dismissal is wrongful or unlawful to prove the wrongfulness or unlawfulness of the termination or dismissal. Thus, it is the duty of the claimant to show by credible evidence how the alleged termination or dismissal was wrongful. In Ndile against Akinso Made 2008 end of the era, part 668293. I can also see it as 2000 LPL 6910 Code of Appeal pages 65 to 66, paragraph D to A. The court set out the test to adopt to determine whether an employee was wrongfully or unlawfully. The test of whether the dismissal of an employee is proper or unlawful is whether the procedure adopted in effecting the dismissal conforms to the condition laid down in the terms of the employment of the employee. To be unlawful, there must be proof that there is departure from the prescribed procedure or that in applying the rules, there is a violation of the rules of natural justice so as to render the formal compliance serve as unquote. Applying the test on evidence of record, the cross of the claimant case is that her employment was terminated contrary to Section 36 of the Constitution of the Federal Republic of Nigeria and Public Service Rules, in that there was breach of principle of natural justice and also non-compliance with the provisions of public service rules in the process of the employment termination. Claimant reached this relief on the basis that her employment was laced with statutory flavor, as the defendant is a statutory body, being a creation of status, and also that the claimant's employment letter, SBCT1, has a protective provision wherein it was stated that the condition of service are the rules obtainable in federal civil services. Both counsels had made vociferous submissions on court disputes between the parties regarding termination of employment of the claimant. Learned Claimant Counsel in his final written address submitted that there was clear breach of public service rules PSR 03061, and there was no invitation of the claimant to attend the disciplinary panel, resulting in the lack of fair hearing, and that it is in clear breach of the rules of natural justice regarding the composition of the Executive of Finance and General Public Committee, which investigated the claimant as the chairman of the board and the registrar, both of whom the claimant has some frigid working relation with, were included in the committee and participated in recommending her sack. Counsel further contended that their presence provided further opportunity for the claimant to be victimized, making them to become accusers, prosecutors, and judge, all rolled into one, unquote. Counsel then submitted that being a right guaranteed by the Constitution, the breach of which in any investigation or inquiry nullified the investigation and any action taken on them is also null. Starting and relying on Adigun against AGOU, citation provided 1987, 1 NWR part 53678. Counsel urged the court to hold that the board decision of 27th July 2016, therefore, based on the investigation of the committee, becomes a nullity. It is counsel's further submission that the allegation of stealing of 23,000 naira leveled against the claimant was not proved as required by law, which is proved beyond reasonable doubt. Hence, the defendant failed to discharge the onus of proof on it, having not established the essential ingredients of the offense of stealing. On the other hand, Leonard Defendant Counsel in his final written address did not agree. Counsel took the position that the defendant rightly terminated employment based on the financial impropriety and the claimant was involved in while in service of the defendant board, despite speaking highly of herself as a responsible principal officer. Counsel drew attention to the claimant's averment in paragraph 7 of her statement of fact and written statement on oath, respectively as follows, and I read. Now she carries out her duties in a responsible manner, attending to all official duties and assignments with dispatch and within the ethics of the profession as chartered accountant, and that I displayed high sense of duty, responsibility towards my official duties without any form of complaint from the defendant. Unquote. The counsel pointed that the genesis of the problem was management report dated 28 January 2016 of the internal auditor of Joy Buku & Co. ABCT 18DT1 to the defendant following the audit of defendant's account for the year ended at 1st December 2013 and at 1st December 2014, which included some shortfalls in the balance of main cash account, giving the notice difference between physical cash accounters and bank balance, which led to issuance of series of queries for explanation. Counsel further pointed that the claimant, in her response to the query XBCC 10, admitted non-lodgement into bank account of the defendant some amount of money to the tune of 645,000 naira, of which he was involved in holding 23,000 naira. That the claimant reacted by issuing the debit notes XBCC 2 to 65, even to herself. Counsel contended that such breaches, lapses, and inefficiency of the claimant in supervising the defendant's account department amounts to gross misconduct, particularly as the external auditors pointed it out in the 2011 audit exercise. Counsel submitted citing and relying on Union Bank of Nigeria against Obo, citation provided at 1995 UNWR 38264 that such acts by the claimant amounts to gross misconduct, which is grave and weighty as to undermine the confidence which exists between the parties in the employment relationship and urge the court to so hold.
Listening to a judgment.
Added breach of the principle of natural justice, Leonard Defendant Counsel contended that by BCT 10, the claimant herself confirmed that she was given opportunity to and defend herself, and that satisfied the Counsel also pointed that the claimant had was also aware of the allegations against her as disclosed in the queries issued to her, which she responded to. Counsel stated that relied on a host of cases on principle of fair hearing in respect of the employee facing disparate hearing, burden on alleged misconduct, such as University of Calabar against Essen, 1996, NNWR part 476, Latobos against Nasad, 1988, 3 NWR part 8 2025, Latin Yusuf against Union Bank of Nigeria Limited, 1996, 6 NWR 632, and contended that the rule of fair hearing has been satisfied once the claimant was able to state her own version of the incident and to defend herself. Counsel further contended that there was no evidence of any victimization against the claimant, in that the defendant terminated not only the employment of the claimant, but also that other persons involved in the same cash fraud. The other one was deceased. Leonard Defendant Counsel also contended that the claimant is not civil servant within the contemplation of public service rules, as employment with the defendant board did not meet the basic criteria for statutory employment and laid down the Supreme Court case of the chief. So, Tamunowe Idomi Boya Obu against NNPC 20039 WRN 76 at page 80, such that the mere fact that the defendant board is the creation of statute is not enough to make its staff enjoy statutory level employment. Counsel submitted that the claimant, not being a civil servant and therefore not entitled to protection under the public service rules, not protected under the public service rules. Counsel placed reliance on the BCT 20, which is a response letter by the Federal Civil Service Commission dated 1st August 2017, wherein the commission, in response to the petition on behalf of the claimant, in respect of the defendant's alleged non-compliance with public service rules, redirected them to the governing board as the defendant as the appropriate body to deal with the issue. Let me state right away that since the court dispute between the parties hovers around whether or not fair hearing was granted to the claimant in the course of termination of employment, the standard is the same. whether the employment relationship is statutory or that of master servant. As what is in contention is the alleged denial of fair hearing in the course of termination of the claimant's employment. And the test of fair hearing is whether the sufficient opportunity was given to the party to be heard an allegation against her. I'll proceed along that line. I find from the record that the claimant was issued several queries, that's in 53, 56, 59, and 11, all which she responded to, like the 54, 7, 10, 12, and provided her own side and explanation on the alleged infraction in the course of which. And that what led to the termination of the employment was the outcome of the defendant's consideration of these queries and responses, particularly queries of 20 June 2016 at XBCT 9 and that of 24 June 2016 at XBCT 11, and the responses of the 21st June 2016 at XBCT 10 and that of 27 June 2016 at XBCT 12, respectively. Learned claimant counsel by insisting that the claimant was not given fair hearing, merely that she was not invited to the board meeting of 27 July 2017, where the decision to terminate her employment was taken, failed to take cognizance of the third principle that fair hearing requirements could be satisfied by evidence of opportunity afforded to a party to defend an alleged infraction, and that this very hearing through exchange of query and response between employer and employee, whereby the erring employee is confronted with infractions and the employee responds with explanations in defense, and decision taken based on the constraint of that allegation in the query and responses in defense could satisfy fair hearing requirements. On that note, and nurture a considered view that in certain circumstances of employment relationship, particularly where the erring employee admitted the alleged infraction, exchange of query response can suffice as a necessary hearing, and such has been judicially acknowledged to satisfy the fair hearing prescription or the rule of natural justice. AK against Unity Bank 2011, NWRR part 1262, page 624.
I like this.
It remains to ask, is the claimant's case falling within this category of disciplinary hearing by exchange of query and response to query? Some relevant exhibits, queries and responses exchanged between the independent and claimant would aid the query. The query dated 20 June 2016, XBCT 9 reads, and I quote,
Okay.
having regard to the Standard Auditor's Management Report for 2013 and 2014 financial years and the subsequent internal auditor's commentary on same, you are hereby required within 24 hours of receipt of this inquiry to respond appropriately to the far-reaching issues raised in the report, particularly the cash received still to be accounted for. I emphasize, particularly the cash received still to be accounted for. Emphasis mine. To underline is the core allegation leading to the termination of the employment. The claimant responded in XBCT 10 query dated 21st June 2016. The relevant parts of the response reads, and I quote, thank you for giving me another opportunity once again to defend the allegations raised in the Standard Auditor's Management Report and now the internal auditor's commentary on same. Now on the issue, 1, cash in hand. A, below is the list of officers responsible for the difference of 645,000. 1, BC Taiwo, 23,000. 2, Luke Out, 274,000. 3, David Onu, 198,000. Total, 645,000. Action taken so far. B, action taken so far to recover the sum. All the staff, including the deceased, have been debited. C, the sum of 28,000 was lodged in January 2015. Emphasis mine as the one I included the claimant relief. So the claimant is number 1 there. BC Taiwo, 3,000. That's the claimant. It is this claimant's response admitting the allegation that was followed with another query dated 24th June 2016 level. Reads, and I quote, it is right law that what is admitted need not be proved. In your response to the query of 20th June 2016, you admitted that you are responsible for the 23,000 naira only, being part of the 245,000 naira been identified by the external auditor in the management report of 2013 and 2014 financial year to be missing from the corpus of the board. Please furnish explanation within 24 hours why you should not be punished for stealing and breach of the board's financial propriety. Again, the claimant responded. In her response dated 27 June 2016, exhibit CT12, she stated as follows: "Thank you for this opportunity. Like I explained at the meeting of 20th June 2016, I did not have cash with me. This is case of omission owing to pressure of work and passage of time, and certainly not one of stealing. I did not steal. I had no intention to steal, but became a debtor by not taking responsibility for the difference in my capacity as head of finance and accounts, knowing how we take IOU to run the office. I made arrangements for set up from my outstanding account of 2016. I am sorry for any inconvenience this might have caused the board. Thank you once again." This claimant's response was followed by a termination letter, termination employment letter dated 27 July 2016, exhibit 13, and all attempts, that's exhibit 15, 17, and 19, by the claimant to reverse the termination administratively failed. Hence,
As the court pleases.
it was clear from the tenor of the defendant's state query of 24th June 2016, exhibit 11, that he was not ready to condone the infraction, but to exercise disciplinary measure against the claimant. The pertinent arising question is, could the claimant's responses on the allegation raised against her in the query amount admission against interest, and what is the legal effect of such admission? What amount admission has been classified by the Supreme Court in Adusei against Adebayo 2012 3 NWLR Part 1288 Supreme Court 534. That's what I call Adetui's case. To the fact that admission is statement, oral or written, expressed or implied, which is made by a party to civil proceedings, and which statement is adverse to his case. It is admissible as evidence against the maker as the truth of the fact asserted statement. Unquote. The Apex Court went on at page 558, paragraph B to C, further explained that admission is a concession of voluntary acknowledgement made by a party of the existence of certain facts. A statement made by a party of the existence of a fact which is relevant to the cause of adverse. A voluntary acknowledgement made by a party of the existence of the truth of certain facts which are inconsistent with his claims in an action. In the Adesui's case, Supra, page 558, paragraph A to B, the Supreme Court restated the effects of admission in judicial proceedings and held us, and I quote, "A crucial fact which is admitted needs no further proof, and same will be taken as established. The basis of the effect of admission was further explained at page 552, paragraph E to F to E to H, thus, and I quote, admission made do not require to be proved for the simple reason that no better proof is required than that which an adversary truly and voluntarily owns up." This has been the long line of this. The Learned Claimant Council had also spiritedly argued that the claimant did not steal, and the allegation of stealing was not proved by the defendant as required by sections 135 and 136 of Evidence Act 2011. By that line of submission, even in the face of claimant written admissions, I take it that the Learned Council was just poised to hoodwink the court into downplaying the adverse impact of claimant's admission of the alleged financial impropriety on the defendant's burden of proof regarding the said allegation. I can only remind counsel that given the trend of judicial authorities on legal effects of admission of allegation, the claimant's admission in her said responses to the queries invariably relieved the defendant of the evidential burden of proof of the alleged financial impropriety against the claimant, which incidentally motivated the termination of her employment. I so hold. But it would have been otherwise if she did not admit same. Also, with this admission of the allegation and the uncontroverted evidence that the other staff involved in the withholding of the cash belonging to the defendant were all punished in the same manner as the claimant, I find no supporting evidence to anchor the claimant's allegation of victimization. More so, as mere presence of the board chairman and the registrar at the board meeting in the course of duty where the decision to terminate the employment was taken does not, without more, amount to breach of rule of natural justice that one should not be a judge in his own case. Because I find that the claimant did not sufficiently adduce evidence to show how the said officers actually victimized her that could disqualify them from sitting at the board meeting where decision to terminate the claimant employment was made. Even the investigation panel did not have any sitting properly because they used the query with the answers. Even when her own express written response to the query, she admitted the allegation that prompted the termination of employment. Accordingly, I find no discrimination against the claimant. I so hold.
As God
As the
pleases.
court pleases.
On the arm of relief bordering on alleged breach of fair hearing, contrary to section 36 of the 1999 Constitution, I find resourceful companions in the judgment of my Lord Honorable Judge B.B. Kaib, PhD, PGA Lagos Division, as he then was, now Honorable President of this court, in Dr. Cecilia Arinye against University of Lagos, suit number NICN LA305 2017. Judgment delivered on February 16, 2018. His Lordship extensively reviewed the current legal regime on the rule of fair hearing as applicable to workplace as follows, and I quote: the recent decision of the Supreme Court in Reverend Prof. Paul Emeka against Reverend Dr. Chidi Okorafor and others, 2017, 14 NWR part 1577, page 410, suggests the fallacy or error of the claimant's reliance on section 36 of the 1999 Constitution, especially with the Court of Appeal decision in Adeyanju against WAEC relied upon by the claimant. Reverend Prof. Paul Emeka against Reverend Dr. Chidi Okorafor and others. The Supreme Court relying on Bakre against LSCSC 1992 NWLR part 266, page 641 at 699 to 700. And Ekunola against CBN 2013 15 NWLR part 1377, page 244 at pages 262 to 263, held that breach of fundamental rights under section 36(1) of the Constitution arises only where the denial of fair hearing has been charged against a court or tribunal established by law, and not before a domestic or standing ad hoc tribunal raised departmentally by parties. In other words, there will be no case of infringement of right of fair hearing under section 36(1) of the 1999 Constitution when the decision alleged to have violated one's constitutional right to fair hearing is that of non-judicial body, unquote. The ratio in that case is that, whereas in this case, the query, the administrative hearing was not a judicial one, section 36(1) should not be invoked. The principle so canvassed in the same judgment being useful and applicable to the circumstances of the claimant's relief, I adopt and apply same in instant suit. From the foregoing legal prescriptions on the rule of fair hearing and effect of admission against interest, as well as the evidence on record, I find that the claimant was afforded sufficient opportunity to defend herself in allegations leveled against her relating to performance of her duties, and the claimant said responses to queries amount to an admission against her interest, not only on the issue of her alleged denial of fair hearing, but also on the substance of the allegation against her as raised in the respective queries. I still hold. The only thing is that the defendant was not ready to condone that error. Consequently, I find no merit in the claimant relief A, as employment was validly terminated in the circumstances of the parties' employment relationship. Accordingly, it fails and is hereby dismissed. I so hold.
As the court pleases.
Invariably, the survival of the relief B and C depends on the success of relief A, which has failed. The relief B is for an order of immediate reinstatement of the claimant by the defendant without any loss in rank and seniority, as well as increment and promotion with effect from 27th July 2016. And relief 2C is for an order of mandamus compelling the defendant to pay all claimant arrears, salaries, and allowances from 27th July 2016 up to date or a statement of employment with the defendant. The employment sought to be protected, having been held in relief A, to have been validly terminated given the circumstances of the parties' employment relationship. The subsequent relief seeking for a statement and associated preservation of claimant's position and pecuniary interest and office and enhancement of packages are no longer available. In the circumstance, reliefs B and C are refused and hereby dismissed. I so hold.
As the court pleases.
The alternative reliefs are seeking for 1, the sum of 15 million naira only for unlawful termination of his employment. 2, the sum of 2 million naira only being solicitors' fees. And 3, the cost of this action as assessed by the Honorable Court. In my view, they suffer the same fate as they also depend on the sources of the main relief A, which failed. If main relief A, which deals with the validity of termination of the employment, had succeeded, it would have opened window for consideration of the alternative relief as a monetary compensation in lieu of reinstatement and compensation for associated legal costs of prosecuting the suit, given also that award of costs is based on principle of cost follows event in line with the provisions of the rules of this court. In the circumstance, the alternative release fail entirely and are hereby dismissed. I so hold.
As
For
the court
clarity and avoidance of
pleases.
doubt. For clarity and avoidance of doubt, and on the basis of reasons advanced in the body of judgment, on the whole, I find no merit in the suit. Same is hereby dismissed in entirety. I so hold. Judgment is entered accordingly and make no doubt to cost.
As the court pleases.
Yes.
As the court pleases.
As the court pleases.
So,
My friend,
is
I
the
told you to
claimant
sit
castle
here.
here now?
Yes, sir. Yes, sir.
Where is the mute is there?
Yes, sir.
Answer what are your comments? Let me hear you and go. Hello, counsel.
My Lord.
The one that did not enter appearance in time. What is your name now?
Okay, I am FM Jato, appearing for the claimant.
SN.
FM.
Okay, SN.
F for fat. Fatima
FM.
Jato. Yes.
Okay.
FM. M for mat.
Okay, Jatu is what? The surname?
Jato is the name. Yes, sir.
Jato.
Jato was not involved in the entire proceedings. Desina was represented.
Yes, sir.
Representing
Sir, when do we get killing?
Who is saying this? Yes, sir. Yes, are you not a lawyer? And you're in a court proceeding?
Yes, sir. I said that I'm a new associate
counsel. Are you a lawyer, really?
Yes, I am.
You are a lawyer?
I am.
When are you called to the bar?
2000.
They did not teach you the courtroom practice and how to address a court.
Oh, I'm sorry.
I take this with seriousness because I myself was involved in training of lawyers over the years, and I won't be here seeing people degrade the standard of practice. Please correct yourself before you take court sanction properly. All right. I'm not finished. I can see that word course at this point.
I'm sorry, sir. I am appearing for the.
You're just making mess of yourself. You know that. Lawyers all over the world, including litigants that are loved in, I just watching you mess yourself up.
I'm sorry, sir. I'm still
my Lord.
Whatever you want, I'll finish my own. Judgment is entered accordingly. Thank you. Counsel, what is your position? You are not even robed.
With all due respect, my Lord, thank you for the considered judgment.
We are not even hearing you because you are not robed. You are supposed to be formally robed for this proceedings.
Sorry for that.
These are observations we are making that is affecting the quality of the.
Yes, sir.
the electronic version of hearing.
Okay,
we
my
can't proceed
lord.
this manner if we want to use innovative methods at the same time people are not complying with basic standards. And you're a Lagos lawyer. I'm in
Yeah,
Port Harcourt
with due
here with the full
respect,
participating in the proceedings.
my lord, next time
And
I
seeing you
will be
not properly
robed.
robed.
I will be robed next time, my
Well,
lord.
thank you very much.
My
And
lord,
thank you
sir.
for the
Thank you very much. I think we are
judgment.
through for the position.
My lord, sir. When do we get the copy of the
Thank you.
judgment, sir?
I'm not listening to you, ma.
Complaining because
No, you are not meant to stand.
and no, I wasn't even the other account. It's still the same thing they said on that day.
I know.
That she already admitted, and then the alternative relief because
Point out, you, did she point out?
Defend herself. That's the basic. That yes,
The father, the people that were part of the hearing were part of the.
You said down on that. It wasn't like they gave us after time to defend herself.
He said I will know where my lawyer saw him that he was. That's the claimant. When I used to be my friend, because when I have the claims, he pays me promise. But what can we do? How to stand against that? The thing don't finish. Student. Yes. Appears now because this woman got shown the last 5 minutes. Allow this to Taiwan. I was thinking of it whether I should go since it's the first one I'm participating in. So I guess. So what do we do concerning the woman's and the other issue we have is how do we recover our documents? Or we should not do friends and do new ones. If we cannot get to them. And my cousin's place is it's a Potter. I don't know whether we can get a dispatch to go and pick it up. Take the dispatch. I mean, you can send a dispatch there. Don't know how much it will cost. Or we negotiate with the dispatch. To go to his place, pick the team out, bring it to us, we can pay him. Just that the dispatch, they are all wonderful. You see the reason why.